to us and we'll see what we can do. So good morning, everybody, and welcome to this webinar on this fine morning. I do hope you're well. As I've already explained, we've got a camera up there, a screen there, and laptops here. So if we're looking in funny directions, please do bear with us. It's just us trying to find where we're actually looking. So welcome this morning to the CCTV and recording doorbells webinar. I'm Gemma Duxbury and I'm a partner. Alex is going to tell you a bit more about me. I'm a partner here at Forbes and I specialise in the data protection side of things. So I'm going to hand over to Alex Berry, who has kindly stepped in at the last moment to cover the first part.
Good morning, everyone. So yeah, as Gemma says, my name is Alex Berry. I am a solicitor in the housing litigation team here at Forbes. As Gemma's just mentioned, you may have been expecting to see my colleague Laura this morning, but unfortunately you've ended up with me. Next slide, please, Hannah.
Very lucky we are too.
Thank you. So just a bit of housekeeping to start there. So we've just got to draw your attention to this note at the beginning. The webinar is being recorded and the slides are going to be provided to you later on. We're hoping that there'll be some time for any questions you might have at the end, but if not, we can follow that up with any questions you have by email. Next slide, please.
We're doing a Chris Whitty today. We've got Hannah in the background clicking the slides for us because I can't cope with that. Okay, so is it over to me? So what we're going to be covering today, obviously this is a really interesting subject, and it's been really quite prevalent in the law recently. I've been advising on quite a lot of it in the data protection sense. So just some of the things that we're actually going to cover for you today. So it's actually understanding what the issues are in connection to this. And it's understanding those privacy and legal concerns relating to the domestic surveillance in a housing setting. And it's about knowing the law and the regulations in relation to this, which is really important. And because it's knowing about your legal obligations under UK GDPR and data protection. We're also going to talk about best practice. So how you can actually support compliant CCTV use and prevent misuse effectively. And then looking at resolving conflicts. So obviously this is quite a prevalent thing, particularly we found in relation to tenants that live in communal buildings where there are communal areas. So we'll have a bit of a chat about that. And it's about how you can be equipped to handle those disputes and complaints. And as Alex very kindly said before, and we are very lucky to have you here, is that at the end we'll try and give you a bit of a summary and then hopefully have time for a Q&A. But knowing me, because I chat a lot, we will not have time for that. So as we've said, you will be getting the slides, and of course you can always ring us, email us at any time. Okay, if we can go to the next slide, please, Hannah. Oh, I'm enjoying this. I like that. I feel like I've got power. So obviously the first thing that we're looking at is the growing use of domestic surveillance in the residential area particularly. I have a Ring doorbell. I don't think I know anybody that doesn't have a Ring doorbell anymore with the offers that they have on. And then there's also, for security purposes, people are using CCTV cameras. And there's lots of other similar systems which can be used and are becoming increasingly popular. So we've seen a big rise in tenants installing these sorts of sorry, I've just had something pop up. Get rid of that. Oh no, what's that? Sorry. So we need to focus on preventing antisocial behaviour and increasing personal safety, because some people feel scared. They do feel concerned about it, and we do have those antisocial behaviour issues. And it's about deterring that and making sure that people feel safe and making sure that they're comfortable in their home. And as well, a lot of people sometimes will do it simply for preventing parcel theft, quite simply because they keep getting their things robbed and they want to see who's taking them and why. So, I mean, I would, to be fair. So that's another reason. So when they're used in multi-occupancy buildings and estates with communal areas, that really does cause quite serious privacy and legal concerns that you can't ignore and that you need to take account of. So if we can move to the next slide, please, Hannah. And I'm going to hand over to the lovely Alex.
Thank you. So we just wanted to have a look at some of the issues that we're seeing repeatedly from a housing litigation perspective when it comes to the use of these sorts of cameras. So first of all, when it comes to antisocial behaviour, we are seeing that having these cameras is actually causing some animosity between tenants. We also have seen that there's some issues actually in the use of them within legal proceedings. And also there's some issues around tenants having permission to actually have the cameras on their properties at all. So I'm going to talk through each of those issues and sort of give some examples of where we've sort of seen these issues. So firstly, the antisocial behaviour. As we know, these cameras have actually been a great way for us to be able to prove that antisocial behaviour is ongoing in any area. However, we've also seen that the fact that a tenant has these cameras pointed in the direction of their neighbour's property is actually causing animosity between the residents and is also becoming a cause of the antisocial behaviour. So we think it's really important that it's managed appropriately and that tenants having such devices to ensure that you can take the steps to deal with antisocial behaviour as it's actually occurring. Often we'll see altercations between tenants and they will reference these cameras that their neighbours have during those altercations, and it makes a bad situation worse at times, and it can inflame already tense relations between those neighbours. Another thing that we've seen in this area is that often we've got tenants who are repeatedly reporting ASB on behalf of their neighbours, and they're desperate for you as their landlords to take some action. However, when it actually comes to taking that legal action, they don't want to support that by providing witness statements, and it's usually due to fear of repercussions by the perpetrator, understandably. But it does make it very difficult for us to be able to do anything if we don't have the evidence. So when verbal reports are being made, we can often anonymise that information, but fairly obviously, it's difficult to anonymise recordings because it's obvious where it's being recorded from. So one way around this, and something that we've seen in the case, is I would consider that you make provision where possible and appropriate to install your own short-term CCTV. A case I had where this was done a while ago was a tenant causing antisocial behaviour repeatedly in a block of flats. Other residents were catching this information, but they were too scared to have their footage used in the proceedings that were ongoing. And obviously it was taking a lot of time on behalf of our client to deal with these reports and the issues, but they weren't able to do anything at that stage. So our client took the decision to install a CCTV camera for a short period of time, complying with all the requirements that we're going to speak about today, and they managed to capture some footage of this particular guy carrying out antisocial behaviour, and ultimately we could secure a favourable outcome using this footage. So the second thing I wanted to have a look at is actually using these recordings within legal proceedings. So as we know, time goes on, your perspective and memory of how an event unfolded can cause some issues, especially when court proceedings are taking as long as they are at the moment due to the backlogs. And there is just no denying that having video recordings of these incidents provides very strong evidence and greatly improves prospects of success. So ensuring that the requirements and the best practice is followed will really help ensure you have the best evidence that we can if we need to take these matters into court. Also, there is the practicalities to consider of actually getting that footage from your tenants and in front of a judge. So the current position and how we are doing that at the moment is by providing the evidence by disc, and that's both to the court and to the defendants. However, I am often met with both defendants and judges that actually don't have the facilities to view the footage in this way, and it has recently been brought up by a judge to us in a case. So I do hope and anticipate that there may well be some changes in this area in the not too distant future, especially as technology continues to move on. And we have had court orders where it states that the claimant is to attend trial with sufficient devices for the parties and the court to be able to view this footage. And if it's something that you want to use, just something to bear in mind, having the facilities available to actually comply with court orders like that. The other issue we're seeing repeatedly comes down to permission. So many of your policies and tenancy agreements are going to have clauses providing that tenants seek permission before erecting these sorts of cameras. It's something to just keep under consideration as cases do progress. I'm involved in a case at the moment, and it's a side issue really, but there's been ongoing tensions between two neighbours for quite some time. One of the issues is that one neighbour feels that their privacy has been invaded due to the height of the camera that's been fitted by the other neighbour. During this correspondence, obviously their reports are being investigated and progressed as usual, but what they've been told is that they need to move this camera down. Basically, it's seen as a reasonable compromise. They've been reminded that they didn't actually seek permission to have it, and if they don't do this, they may need to remove the camera altogether. So it's something to consider as cases are ongoing, and also just ensuring that your tenants are being treated fairly and consistently. It just can help diffuse these situations as they arise. Next slide, please, Hannah. So I've talked about examples as we've gone on, but there is just a specific case I just did want to mention while we're looking into this, and this is the case of Malloy and BHPA Limited, which was a 2021 Court of Appeal case. So the neighbour in this case had been suffering racist abuse on and off for quite some time, and was actually advised by the police to install a CCTV camera over their front garden, which also covered a path which was shared with Mr. Malloy. An injunction was obtained, and at some stage during the proceedings, Mr. Malloy was alleged to have breached the order. Committal proceedings were brought, relying on 6 alleged breaches, and the judge was not satisfied that the criminal standard of proof was met for 5 out of these 6. But on the 6th alleged breach, having viewed the CCTV, the judge was satisfied the breach was found, and that Mr. Malloy had been attempting to intimidate his neighbours by saying words knowing that they would be seen on the CCTV. So Mr. Malloy appealed this decision for other reasons as well, but for our purposes, on the basis that he'd been having a private conversation with his wife and the recording infringed his privacy. And the appeal was dismissed on both grounds. And in his judgment, Lord Justice Jackson said of Mr. Malloy's, the points that he'd raised on the positioning of the CCTV, I'm just going to read from his judgment. If there had been no history of antisocial behaviour, there would be no justification for the use of CCTV. But that is not the situation here, and the appellant has to take account of the effect of his behaviour on his neighbour, in the everyday and legal meaning of that word. His rights are not the only ones to be considered. He went on to say that the Article 8 right of the victim and her family to respect for their family life overwhelmingly outweighs any consideration of privacy which the appellant and his wife would normally be entitled to expect. He said it is not normal to be recorded by one's neighbour whenever one leaves or returns to one's home, but the circumstances here undoubtedly justified a departure from the norm. So if antisocial behaviour in question is severe, then this video footage will be accepted as evidence. And he said here that the behaviour of the defendant justified the use of this footage from a shared area. So just something to consider, that the Court of Appeal have said that is the use of the CCTV in this sorts of scenarios is justified. So next slide, please, Gemma, back to you.
No, it's so interesting to hear it from your perspective, because even though we're talking about the same subject and exactly the same thing, we look at it and see it in completely different ways, you know, because obviously sort of you're dealing with the ASB side and the court side of it, whereas we sort of get the issues beforehand. So it's really interesting to hear all that, to me, because it's just a completely, I mean, we were saying this morning, weren't we, about that leak of the legal aid information, you know, that at the end of the day, it's the different perspectives, and I find that really interesting. So we're going to move on to me now, which is more of the data protection element side of it. I can see that we have got some questions coming in. We will try and get to them, but please do bear with us. Okay. So the first thing I'm going to talk about is effectively the common complaints that you are going to hear. Alex has already touched on that. My neighbour's camera points at my door. It points at my garden. They're recording our shared hallway. I can hear conversations on their camera audio. They didn't ask my permission to install it, etc. So these are all the kinds of things that you've probably heard or are going to hear. And sometimes, in fairness, they can cause genuine distress. And like Alex has said, it can escalate situations. So, you know, you have to take these things quite seriously and listen to people, because it can affect the quiet enjoyment of their home. Next slide, please, Hannah. So hopefully this is going to, there we go. Thank you very much. So where the problems arise. So when cameras are placed in shared areas, that's a real tricky point, because obviously it's going to be recording everybody and everything. So it's going to not just be covering their property, it's going to be covering where other people go. And that can be members of the public, other tenants, members of the housing association who are visiting, medical staff, carers, all those sorts of things. And this is where your complaints tend to stem from. And what originally started as what was considered to be a safety tool or a protective measure, actually, even though it's unintentional, can become a real source of tension, as Alex has already said, and cause those privacy violations and end up being actually a legal liability and a real problem. So you can have cameras recording outside of the tenant's boundary, as I've said. So the shared hallways, the stairways, the front doors, if there's communal gardens, all those sorts of things. The audio record is often automatic. So if it just picks up any kind of movement, it will start recording, and it will record those voices as well as the images. And that can capture private conversations, which can be quite invasive. Devices end up being installed without permission. And what we suggest you look at there is the tenancy clauses. A lot of this stems back to your policies and what the tenancy agreement says. And it's really, really important that these are covered off in there, because at the end of the day, if they're not in your policies and they're not in your tenancy agreements, there is no real reason other than the legal side of things where you can say that they can't do it. So a lot of the time, housing association policies will actually stipulate and say you cannot fit any kind of recording device to the exterior of your property without our permission. And as do the tenancy agreements. So first of all, the first step is making sure your documents and your policies are in place, because effectively then, if they do actually put something up and say, I don't care what you say, I'm going to put it up anyway, well, you can actually flap their tenancy agreement in their face and say, well, here you go, actually, no, you can't, stop it. As I've said, there's a lot of other people that may feel that they're being watched, not just tenants, it could be all sorts of people, and that can eventually lead to harassment complaints. So this is a really big issue, and this is why we're having this webinar today to talk about it. If we could go on to the next slide, please, Hannah. So I'm afraid now I'm going to cover the boring law bit, the legislation bit. Now, I know it's not very exciting, it's not a sexy subject, but I'll try and make it as interesting as I can for you. So the relevant law in relation to this is obviously the UK General Data Protection Regulations and the Data Protection Act, which has been around quite a long time. And all of this does apply to Ring doorbells and CCTV. There is specific advice and laws in relation to those items. If a tenant records beyond their own space, like in a shared hallway, like we've discussed, or at a front door or anything like that, data protection laws absolutely apply, because they cannot possibly argue it is just for personal use, because it is in a public space. So what we have to remember is that the data protection regulations, they govern how personal data is collected, how it's stored, and how it's used. And this does apply to the camera that records beyond your private property. So some people may even have houses with CCTV in their back garden, for example, if they've got an alley or a ginnel, as we call it up north, in the back. Some people have CCTV at the back and they say, it's on my garden, that's not an issue. The issue that you have is if it goes beyond your boundary. Now, I have a Ring doorbell. I don't know if any of you do, but one of the questions it actually asks you when you're setting up is where to set the boundary for it to trigger. And that's a really important question, even though it's not identified to you, because actually then you can set it so it literally just covers up to your boundary. So that's just little warning sign for you that does actually come up. Now, if you are recording anything that is beyond your personal space, beyond your boundary, then it does, under the law, require signage, transparency, and you have to have a lawful basis for that use. So it's really, really important that you know that this legislation applies to these doorbells and these cameras, and that there is protection there. Alex has already touched on the Human Rights Act, so I'm not going to go over that again. And there is clear ICO guidance on the use of domestic CCTV systems. And the ICO is the regulator for, it's the Information Commissioner's Office, and they are the regulator relating to data protection in UK GDPR. This is about CCTV that's been installed by individuals rather than yourselves, and the guidance really gives you some key points to take away, and that includes that CCTV that's installed at a private property, as I've said, will be exempt if it only captures footage of their private property. So bear that in mind when I was saying to you about the boundary on the Ring doorbell. Where the CCTV captures footage of individuals beyond those boundaries, then actually it is subject to this legislation. It becomes what's known as non-personal. So it ends up falling under this legislation. And if the CCTV or the Ring doorbell captures images outside of that boundary, the person who owns that doorbell or that CCTV becomes known as a data controller under the legislation. And that's why the legislation then kicks in, because they are in control of that data and what it is used for. So just bear that in mind. Then there's got to be a lawful justification for the use of that, such as an example being the prevention and detection of crime. So they could have been burgled before, so they could say that their lawful basis is because of that, and they're scared and they want to be protected. That has to be documented in writing, and they have to set out the reasons as to why they want to do that. And if it does go beyond their personal boundary, why it's okay that it does that, because potentially it's invading their privacy. So ultimately, if a tenant does fit something that covers a public area which captures images of people other than themselves, then they are going to be subject to that legislation. So tenancy agreements, as I've already mentioned, they can prohibit alterations or anything that causes a nuisance or harassment. And in that, we would actually be making specific reference to your doorbells, your recording devices generally. If we can move on to the next slide, please, Hannah. There's been quite a big case recently. You might have heard of this, and it's called Fairhurst and Woodward back in 2021. And this was where Dr. Mary Fairhurst, they were they were neighbours. So her defendant was John Woodard, who lived next door. So they were two neighbours that lived in Oxfordshire. And Mr. Woodard installed multiple video and audio surveillance devices all around his property, and that included a Ring doorbell and cameras, which were triggered by motion sensors and spotlights. So these devices were positioned to areas beyond his property, and that included a shared driveway and a car park that was used by both the doctor and John. So it was covering beyond the boundary, as I've already discussed. And Dr. Mary Fairhurst said, hang on a minute, I'm not happy about this. These surveillance practices are breaching my data protection rights, and actually it amounts to harassment because you're recording everything that I do. And the court in this instance did find there to be a breach of data protection and harassment. They found that the use of the surveillance cameras violated the Data Protection Act and the UK GDPR, and they identified specifically breaches of the principles of transparency, purpose limitation, and data minimisation. The audio recordings captured conversations beyond what was necessary for the crime prevention. So that ended up infringing upon Dr. Fairhurst's rights, which caused her significant distress. And it actually ended up to her leaving her home in the end. So she also brought a nuisance claim, but that was actually dismissed by the court. But they were successful with regards to harassment and data protection. And that was quite a prevalent case in the papers and the news. So you might have actually heard of that. Next slide, please, Hannah. Okay. Oh, what's up from there? Sorry, bear with me 1 second. It's disappeared. There we go. So the data protection duties, best practice for tenants. As it says up there, the ICO guidance contains all the steps that individuals should take if they are recording anybody beyond the boundary of their own property. So as you can see there, it's advising it should be positioned to avoid intruding onto a neighbour's property or shared public spaces. It advises that audio recording is very, very privacy intrusive, and they actually advise you to disable that audio recording, so it's just taking the visual. They ask you to consider if CCTV will prevent the problem, or could something actually less invasive be used so that it's not going to impact on other people's privacy, such as alarms or security lighting. And then it's again reiterating there has to be a lawful justification for the use of that recording. You need to make sure that that's there. You have to make sure that signs are displayed and that any footage that is taken has to be kept and secured, and it can't be disclosed to anybody without having a real legitimate reason to do so. Footage must only be kept for a short period of time, so 14 to 28 days before it is deleted. I'm sure if you watch some of the crime TV series like I watch a lot of the time, when the police go to try and get footage, they say, oh, it's gone, we get rid of it after so many days. And that's quite right, because under the data protection legislation, you will probably know you are not supposed to keep data for longer than what it is required. And individuals must also comply with requests from their neighbours who appear on that CCTV. Now, in reality, the chances are the tenant will have genuinely no idea about any of this, All they are concerned about is their personal safety and protection, and they want to make sure that they are protected and they are able to use these devices. And that's all they're bothered about. They don't care if it records other, members of the public and things like that. They're not interested. They probably don't even know who the ICO is or what this data protection duties are. So you just have to bear that in mind when dealing with tenants. But also as well, that many of these tenants will not be in a position to comply with the guidance and with the data protection legislation. So they need to be very, very careful with what they're doing. Can you move to the next slide, please, Hannah? So we're now going to look at the consequences of non-compliance with data protection law. So when tenants misuse CCTV or these Ring doorbells, there can be real consequences for it. And if devices breach GDPR, so for example, as we've discussed, recording those shared spaces or the audio without having that justification, they can become liable under the law. So the ICO can step in. As I've already said, that's the Information Commissioner's Office. They are the ones that regulate this. They can effectively step in, and particularly if it's in serious or repeated cases. So somebody just keeps on doing the same thing. But more commonly, neighbours can actually take direct legal action. We've actually found that the ICO do have teeth to deal with this, but when it comes to sort of smaller breaches and things like that, they tend not to get too far involved in it. So a lot of the time people will get frustrated with that and they will end up taking their own legal cases, like Dr. Fairhurst did against her neighbour. And as we've seen, they had to pay compensation due to that excessive surveillance and recording conversations without consent. So there are legal consequences to this. And then, as well, as we've already discussed as well, that there are housing related consequences. So potentially it will be a breach of your tenancy agreement with them, or it will be a breach of your policy, at which point you can then take some action. So you may need to take formal enforcement steps, because if they've installed it without permission and they're refusing to listen to you, they're refusing to take it down, you can take legal steps toward that. And of course, the disputes, it could cause nuisance or harassment to a wider community. It can damage your reputation and it can damage the reputation of the community. So this is why we feel that education and clear policies and tenancy agreements are so important, because effectively it's preventing the issues before they arrive. It's about making those tenants aware of what the situation is. And it's not taking away from the fact that they might be frightened, they might be scared, they may have a real genuine reason for doing what they're doing. But if it is potentially going to breach their agreement or the policy with you, then they need to know about it and they need to understand. Next slide, please. Okay, so your role and responsibilities in relation to this. This is a real balance about safety concerns with privacy rights. You are in a really delicate position here, because your role is to make sure that you've got a safe, respectful community. And part of your duty is to make sure that you support those tenants who feel unsafe, but you've also got to protect those tenants from being surveilled when they don't want to be, or they feel that they're being harassed. So it's a really tricky balance for you, and I do empathise with the situation. So we would always, advise you to try and respond proportionately to any complaints that you have. Try and understand the full facts, why it's gone on. Is the tenant aware of the data protection legislation and your policy on the tenancy agreement? As is with everything, make sure you record and document everything that is done in relation to that. Your conversations, anything at all, make sure that you document that. And then we would obviously advise that you work with your data protection officer, your legal advisors, and also the resident engagement teams to make sure that that relationship doesn't break down. Often you will need to consider this very much on a case-by-case basis, and it is balancing tests between the right to install it, but then the right to respect the privacy of others. So it is a really tricky situation. And in some cases, it may be possible for a tenant to take steps to ensure the CCTV doesn't capture that footage outside their boundary. Like we've said, in houses or where they have private areas, and with the Ring doorbells and things like that, you can actually set those boundaries. So there are ways around it, but that's not necessarily always possible, which is with the blocks of flats and the apartments and things like that. So it is really tricky. Can move on to the next slide, please, Hannah. So the best practice, housing association actions, this is what we would be advising you to do. As I've already mentioned, check those policies, check your tenancy agreements, making sure that there is mention of installation of CCTV, recording devices, ring doorbells, whatever you want to call them. Make sure that there is something referred to in your policy about what they want to do if they want to get them installed and the process relating to it. And then also in the tenancy agreement as well. It's really, really important you do that. Make sure that there's an approval process. So as part of that policy and tenancy agreement, make it very clear that they cannot do that. They cannot install any recording devices without your consent. They have to come back to you and they have to speak to you about it and get your consent and support to do it. Provide clear guidance leaflets to your tenants. I mean, it says when entering tenancy, but I think at any time at all, to be honest. You know, maybe send it out. I don't know if you have newsletters, tenant newsletters, residents newsletters, things like that. Flag it in those. Try and make it clear that, you know, this is the situation, and or while you understand people want to protect themselves, there is that risk, and that you do have to balance it with the law that's in place. And then again, you know, training staff. This is really, really important. It's making sure that your housing officers know what to say, that they know what the position is if the complaint is raised, because that can make a massive difference, because a lot of the time they don't actually know about this, and that can cause issues. Next slide, please, Hannah. Oh, we're whizzing through. I know, I think we'll be able to try and hopefully deal with some questions here. So the summary and what to remember, you know, at the end of the day, tenants do have a right to use these, but they have to respect the law and they have to respect your policies and procedures. They can't just go off and do whatever they fancy willy-nilly. If they're recording shared areas, they need to know that those data protection laws apply. So you must set out clear rules in those policies and procedures and tenancy agreements. Provide support for responsible use. You know, people can use these devices, and if they're using them correctly, and as Alex said, there are so many ways that actually these can be a real positive with regards to dealing with antisocial behaviour or disputes between people. You know, they can actually be a benefit as well as a negative. So you really do need to bear that in mind. And it's providing that support for those people that can use it and are using it in a responsible manner, and making sure that you act on complaints, because this is legal, this is set out in the law, and it could lead to some real problems. And we found that proactive management can lead to prevention of conflicts and liability, because if you've got that clear process, you've got that clear procedure, and everybody knows about it, they know what they can and can't do, and that can be a deterrent in itself, that people know that they have these cameras and they can do them. And there's lots of useful resources out there. The ICO website is quite helpful, and it does have guidance on there. It has the CCTV guidance, and it also has lots of other information related to data protection legislation and laws. And then again, you've got the Housing Ombudsman, which provides neighbour dispute guidance, which again covers also the recording devices. So I think it's a bit of a whistle-stop tour, but I think that's what we've got to. But we've got quite a few questions, so I'm going to start having a look at this. So the first question is about tenants having cameras inside the property. Now, this actually, we've had quite a few queries on this recently, where incidents have been where tenants have actually recorded you whilst you've been having a meeting. And they've not necessarily told you, and you found out afterwards. What advice can I give about that situation? So that's a really, really good question, because that is coming up a lot at the moment. The best advice that we can give for that is that if it is in their home, the meeting, and it is in their personal space, really the ideal would be that they get your consent to record the meeting. However, they don't have to. What it focuses more on is what they do with that information. So we've had a query recently with regards to a couple that were in a flat. They were having some issues. They had a meeting within the flat. They actually disclosed that they were recording it, and the members of staff were okay with that. They knew about it. However, they then proceeded to go and post it on YouTube. Now, that was not acceptable, and that was when we were able to step in. Again, I think that you need to make sure that this is in your policies. You need to have it in your policies as to whether or not it's against the association's policy, whether or not they should require consent because that's what you want them to do. But they are able to record it. It's then more about what they do with that recording. So I hope that's answered the question. It's not necessarily the answer people want, but you know, at the end of the day, if they're using it for personal use, and so for example, we might get tenants that have a health condition, so they may have memory loss or something like that, dementia or Alzheimer's, or they might not be able to remember conversations that they have. So actually they're recording it to help them so that they can listen to it again and they can check what was said and make themselves feel comfortable. Exactly. And that, you know, you can understand that that's actually okay, because they're doing that because it actually helps them, and they're not going to do anything maliciously with that information. It's what happens then and how they use it. So hopefully that's answered that question. Oh, we've got lots coming through. So I've done that question. Is permission required to have CCTV? As I've said, it's not a case that people are entitled to use Ring doorbells or CCTV. What we would advise is you make it a part of your policy that they don't do it without your consent, and you make it part of the tenancy agreement that they don't do it without your consent. And it's again about advising tenants of the situation, making sure that they understand the legal repercussions that can possibly happen, and just making sure that everybody is aware of the situation. So you actually need to make that a part of your policy, because people can put it up, but then it's like I say, it's not necessarily about it being there. It's about what it's recording, how long they're holding it for, what their reason is for having it, how long they keep that data and what they use it for. Oh, questions are coming in thick and fast.
I've seen there's a couple there about the case that I talked about. So yes, the case was Malloy and BHPA Limited, but I will ask for the full case citation to be sent out with the slides for you. So I think that there's a couple of questions there just asking to clarify about that case, but I'll ask for that to be sent out for you.
Perfect. Thank you, Alex.
Sorry, I'm obviously speaking a little bit fast there because of the view of
What was the name of my case over there?
Sorry about that.
No, don't be that. To be honest, I get lost with the citations. It's that they're not easy to follow. So the ones is it mentioned in the slides as well? I'm not sure.
It's not actually on the slide, but I will ask, and I can also attach the judgment for you, so that's fine. It's not too long a read actually. I had a read of it all the way through yesterday. You'll be glad to know.
Okay. Is it difficult to refuse permission to install if the tenant claims it's for personal safety? Yeah, I think the answer to that is it probably is difficult to refuse permission, but I think perhaps that's the whole point of it, is that you need to have those discussions with them. And the first starting point is by having it in those policies and in those tenancy agreements that they have to get that permission. And then I think you have to potentially do a risk assessment. So why are they saying it's for their personal safety? Has anything actually happened?
Yeah. It's a bit of a different slant on it, but I have had, and I've seen in the past that it was a new build property and they couldn't add anything to the outside of the property for a couple of years, and there was a bit of a back and forth about that, because obviously they were saying, well, we want it, but they just weren't allowed to add anything to the outside of the property for a period of time, and that had to be the reason, and they found a way around it. I don't know whether we ended up having it through the window. It was quite a while ago, but again, those sorts of issues do crop up when it's going to affect the sort of building, as it were. Yeah. Well, not only that, people do put things up in a not the best way, shall we say? So it can be. We also don't.
I like you putting a CCTV camera up, to be fair. Somebody said you mentioned outside. What if the cameras are inside and looking out of a window? It's exactly the same. It's exactly the same whether it's inside or outside. You know, we would still expect them to get consent, provided that you've made that very clear to them. And it's about what they record, why they're recording it, how long they record it for, and their reason. So if it's inside or outside, it doesn't really matter. It depends on what it's covering and what it's recording. So I've answered that one. Sorry, I've got the worst mouse in the world that goes in the completely opposite direction to where I'm going. Your CCTV policy says we neither give permission nor deny it, which I feel is very open-ended. I would actually agree with you. I don't think that actually deals with the issue at all, and I think that would need to be looked at, because I would 100% say that the advice would be that you say that they have to get your consent, and you don't have to restrict it. You don't have to make it particularly about that, because I'm sure that a lot of the time your policies will already say you can't make any alterations. So that, I mean, I would argue that is an alteration to the fabric of the building. but it is a bit of a stretch. So I think you're actually quite correct. You know, you need to actually say, you need our consent. You have to get our consent, because otherwise that's not just going to get you anywhere, really, is it? So you have a case here where a private neighbour has a doorbell on the door which faces directly across a small hallway to a social tenant. The social tenant has raised concerns about this and advised around ICO. If she has contacted ICO, can she pursue this further in relation to invasion of privacy? Yes, I think is the answer to that. I mean, we've seen already that it's not only considered an invasion of privacy, but it can also be considered to be harassment, and it can also be considered to be a breach of human rights. So yes, they do have options. If she's contacted the ICO should be able to give them guidance. To be honest, it can be a bit grey. However, I think it might be worth having conversations with the neighbour to actually say, look, we have these concerns. Because it's been flagged to us that you have a camera, it's recording. I mean, it's not just recording the neighbour, is it? It's recording anybody within that internal building. So I think you're perfectly within your rights as the owner of that property to be flagging that and raising that. But I mean, it depends, because like I say, if they're getting rid of the recordings after 24 hours, if it's for any particular reason that they can't justify, then essentially they shouldn't be doing it. But yeah, you need to approach it and have that conversation, because I completely understand why the tenant feels like that, and they do have all the legal options they can pursue.
Yeah. It's difficult, especially when you've got quite small sort of hallway areas, to not catch each other's doorways, and that is obviously not the point of what you do. Well, some people it is, but it can be difficult to manage.
We've got a comment here to say it's very difficult to address a tenant who has installed it without permission and is refusing to take it down. Would you want to be spending money for legal action to get the camera removed?
Well, I suppose the balance there is how big the problems it's causing you, how much time it's taking you to deal with complaints. Is it actually benefiting anyone? If you're spending hours and hours dealing with many people in that block complaining about the camera, then on the balance of what you're spending money on for legal action, that might be the best use of those funds. It is a difficult one, but it's part of the balancing act, really, that we see when we're sort of advising on this kind of action.
Yeah, it's so tricky to answer those sorts of questions, because it is a balance. That's exactly what it is. And it's like Alex said, you're balancing actually the problem with, oh, can we be bothered doing anything about it?
Yeah.
I mean, worst case scenario, like you say, if it's in your policies and it's in your tenancy agreement, you can get them out. You can actually get them out if you want to go down that route. So I think it's actually assessing it on a case-by-case basis and identifying what the actual problems are, like Alex says, and doing that balance as to whether or not you want to consider taking legal action. Okay, so we've done that one. Someone here's mentioned that they have a domestic violence victim who has cameras pointing down the street. She said police have told her it's okay due to this. Oh, the police, the police, the police. They do cause us a bit of a headache with this, don't they? I mean, in fairness, you could argue she has a justifiable reason for having that. However, it depends, again, how long she's holding that information for, what she's using it for. If it's just for her personal use and she's just checking it and looking at it and then deleting it and getting rid of it, I think she could argue, because she is a domestic violence victim, that potentially she has a legal basis. But again, it depends on what's being recorded and what she's doing with it. So I think the issue would be if somebody who lived next to them or down that street comes along and says, hey, I'm not happy about this. You know, I don't want you to be recording me and doing things. That's when it will be a problem. But I think that she just definitely does have a legal basis, but perhaps it's worth having that conversation to ask her, what do you actually do with the recordings? How long do you keep them for? Do you listen into other people's conversations? What's it recording? Those sorts of things. It is a difficult one.
You want to support people who are in that sort of scenario, but there's just so many. I think part of the problem in this area is there's so many competing issues to take into account. It is really a case by case kind of area.
Yeah, it's very, very tricky. Somebody has put, my understanding is that the ICO won't take any enforcement action. They just offer guidance. Is this correct? Now, I have to be very careful when I'm talking about the ICO, because I don't want to get into any trouble. But as I did mention earlier on, yes, they do have powers, but we haven't necessarily seen them unless it's a very serious situation. So they do have certain powers. It's whether or not they choose to exercise them, and that would be viewed on a case by case basis. Did I answer that in a politically correct manner? Excellent. So we've answered that one. So you've had issues with residents on tenancy agreements that don't include any detail regarding CCTV permissions, but you do control the usage of the CCTV. And in this case, permission was granted over 10 years ago. However, they've only recently put up a CCTV camera. Would we still be able to take action based on our current policy and procedures? I think it would be quite difficult, unless, like I say, you have any complaints, and it depends what they're recording, how long that is. And I'm sorry to keep going back to the same, but it is the same things for everything. Why are they doing it? Have they got a lawful basis for it to be there? What's it recording? Is it within their boundary? Is it outside their boundary? Is it audio? Is it just visual? What's the reason it's there? It's all those sorts of things. But if it's not in your policies and your agreements now, I do think you would have difficulty in.
I think my understanding is that it's in there now, but when the tenant signed up, it wasn't. So they now can. Sorry,
well, I see,
that's
so
how. Originally it wasn't, but now it is.
I'm
Can
with
they?
you, I'm with you.
Sorry.
I'm multitasking, trying to do 75 things.
Hopefully
Right,
that's
so in
correct.
that case, so if they signed up 10 years, I mean,
It's not in the tenancy agreement, but it is now in the client's policy and procedure.
right, if that is the case, whichever way it is, if that is the case, then yes, would be the answer to that, because usually it will contain in most tenancy agreements, it will say something along the lines of that you will follow any reasonable policies and procedures that are introduced by the housing association. That's what it would normally say, and most tenancy agreements would say that. My next question would be, has that never been reviewed? Because that's quite a long time, isn't it, to have just sort of the same tenancy agreement in place. I mean, obviously it's difficult to comment without actually seeing it, but yeah. So we've answered both sides. If it was in there and it wasn't, so yeah, if that is the case, and then I would still say that you would be able to rely on your current policy and procedures because they are reasonable, and a tenant would be expected to abide by reasonable rules and regulations. Sorry, thank you for that, Alex. I really appreciate it.
I might have been wrong.
Well, it's handy to have two people in the room. So if someone records and it captures antisocial behaviour, would they be able to keep as long as necessary as per the law and not have to delete it within a short time? Yes, is the answer to that. Absolutely. It depends though, if they're, I mean, it's a bit of a difficult question, just keep hold of it, what they're keeping it hold of for, unless it's been reported to the police and they're actually doing a criminal investigation, and it's not going anywhere, then potentially that would argue you could keep it for years and years and years and years, which just isn't the case. So I think it would be reasonable to keep it for a period of time, where if you feel that any action will be taken, and it might be worth then liaising with the tenant to have that conversation with them, and to see if you can find out with the engagement team and perhaps even the local police as to whether or not it's been reported and if any action is going to be taken in relation to it. Oh, need a breath, I know. So does this also apply the same to shared owners who hold a lease? I'm not quite sure what that question is, but I'm thinking if it's saying that it's a property that's got two tenants in it, for example.
Is it not shared ownership?
I'm not sure.
I mean, surely it would apply to
it would apply
anyone.
anyway. Yes, it would apply to anybody in any situation. It would apply. It applies to me as a homeowner with a mortgage, and I have a Ring doorbell, so it applies to me. And if that goes beyond my boundary, then I become a data controller, as we've discussed, and it falls under the legislation. So yeah, it would apply to everybody on the face of it. If I've misunderstood the question, which is quite possible, please do let us know. Okay, we're just trying to whiz through and answer as many as we can, because obviously you have raised it. We're gonna have to follow some up, I think. Yeah. Is there any there that do you understand that?
How do we enforce removals?
So how do we enforce removal when there's been no permission and they've drilled into a communal building directly outside their flat on the second floor?
Probably injunction.
Yeah, potentially. And I think again, check your policies and procedures first, because potentially without having that requirement for your permission, have they actually done anything wrong?
Yeah, I suppose. So check your tenancy agreements, your policies, your procedures on how many chances you give someone before becomes do we do a warning letter? Perhaps potentially you're looking at an injunction to make them comply with the terms of the tenancy agreement to remove things like that.
Oh, sorry. So we've answered that one, I think. It's alive. Should we be advising tenants to disable the audio on their cameras? I've had a recent one. It's been picked up by a neighbour and has proven the verbal abuse between new neighbours. Should I disregard this evidence and ask to disable the audio on their camera? I don't think you should ever be advising anybody to do anything necessarily, other than perhaps making them aware that it depends on what they're recording. So we have sort of said, in certain circumstances, it might be worth disabling the audio. However, it might be the audio that is actually showing the antisocial behaviour, because it might not necessarily be physical. So I think you have to look at it very much on a case-by-case basis. And if this is a case of verbal abuse between two neighbours, I think that you shouldn't necessarily be advising to disable the audio on that. However, again, we have to go back to what we've sort of been the flow of the whole sort of presentation has been, which has been, you have to be able to have a justification for holding it, which I think potentially they do, depending on what the verbal abuse is, how long has it been going on, how bad is it, is it necessary, is any action going to be taken with regards to it. So there's a lot of consideration to think about it, but I don't think you should be advising people one way or the other. You can advise them of the potential issues that arise from it. What do you think, Alex?
I mean, I'm just thinking about the question is very similar to the Court of Appeal case that I'll send the link to. Have a read about it. There's a lot of narrative about it as well, from various people on the internet about that case, because that did come down to he saying, well, it's a conversation with my wife, and it's like, well, you knew you had an injunction not to be racially abusive to her. So potential justification there, I suppose.
It's really difficult, because you do actually need to be able to, in certain circumstances, use that. Like, I think
it's helpful for us, if we're taking cases to court, you can show and document, like Gemma said before, it's important to document everything, that you've had the conversations about what the requirements are. It's up to the tenant whether they do it or not. But if we then need to take further action, we did ask, we pointed out that this is what they should be doing. They didn't do it. It's up to them to do it or not, really. There's only so much we can sort of handhold in that sort of scenario. It would be my opinion on that.
Oh, blimey. Right. I'm just having a look. Somebody asked a question, so I was just having a quick look at it. We might have to come back on some of these.
I've spotted one from someone that I know that I might be able to pick up with them.
Amazing.
Yeah.
Is that one?
Yes.
Right, okay. So we're going to go back on that.
I will, if Hannah can provide it to me, I will have a look into that one. I think I need to have a little look at it, but I know I'll speak about it later.
So can you ask how you can ever consent to a Ring doorbell in a communal area where it's going to be a direct breach of legislation? I'm sorry to sound like I'm on repeat and sound like I'm going to break the record, but if we just keep going back, you have to look at the reason as to why it's been put up there. It has to be, because it can be justified in certain circumstances, but it depends what you're going to use it for, what you're going to use that footage for, how long you're going to hold it. This is not a clear-cut area. This is a grey and murky area that people, I mean, it's only that recent legislation really, and that recent case law that we're able to base this off. And one judge might look at it completely different to another one.
I've never had a judge reject a case where, because quite often they are in quite close quarters. I've never had it actually raised, but that doesn't mean to say that we should just be doing it anyway. We still need to follow the law, but in terms of experience in court, I've not had that be an issue.
Yeah, I just think, again, you're looking at the reason for it.
Yeah,
you're looking at the reason for it. So I mean, I would quite clearly argue that a lot of the time, for example, my husband is away working, I'm at home with my two children on my own, and I've done it for safety purposes. I'm recording within the boundary, I get rid of the data, and I'm not publishing it or doing anything that I shouldn't be doing with it. So again, I think that at the end of the day, you have to be looking at the reasons why they want that camera there, and they have to have a justifiable reason for doing so. Can you provide advice on doorbell cameras in flats where the front doors face each other, so one would record the other, the door being only
Similar.
I mean, again, that's a similar situation. Have they got a problem with that neighbour? If it's only recording the front door across the way, actually, why have you got that? What's the point of that? Unless you've got an issue with that neighbour.
Yeah.
The other thing is to get the consent of the neighbour. If the neighbour if it's only filming the door across from them, speak to that neighbour and say, look, we've got this doorbell, it's recording your front door, do you mind? And they might go, no, actually, I'm really happy about that because it's offering you further security.
I suspect, like I said, though, these issues are coming to you when it's caused the animosity between the tenant, but it's, yeah.
The internal CCTV issue is more that the CCTV is pointing out of the window and recording the neighbour's garden. So that's the same as the cases that we've discussed already, and the same issue of the fact that if it goes beyond your boundary, you then become what's called and known as a data controller. And that means it falls under the legislation. So you need to make sure that that tenant is aware of that legislation, and you need to know why they're doing it. Again, it could be because they've got a problem with the neighbour, and how long they're keeping it, what they're doing with it. So it's all the same sort of questions. Right, I think that's as many as we can do.
Yes,
we've charged through and tried to answer as many as we could, but unfortunately there's still quite a lot there. So Hannah, if I can ask you to collate those, and we'll see if we can look through those and come back to you and answer all of you, because I am mindful that we haven't got through all of them, and I do apologise for that, but it's a very emotive subject, it's a very current and relevant subject. But like I say, it isn't clear cut. And I know that sounds ridiculous coming from a lawyer, because we say that about everything. And it's very grey. That's another one, isn't it? But yeah, unfortunately, that is the position. We really hope that it's been helpful today. Thank you all so much for taking the time to come and join us. It really means a lot to us that you do attend these webinars and you do listen to us. You've got our details there. Please don't hesitate to contact us, and we will check through those questions and try and come back to you with an answer. But if you need any further support or help at all, please reach out and don't hesitate to contact us at any time.
Yes, just a quick one. I've been asked to mention that on the 5th of June, the next in our webinar series is going to be what to do when you receive reports of an abandoned vehicle. So just another one to look out for in a few weeks' time.
And thankfully, I'm not going to be on that one. No. I'm sure you're all very fed up of me, but it's been a real pleasure to talk to you today. Thank you very much, everybody. Take care. Have a lovely day. Bye.